WAAY 31 Lawline, with guidance from the personal injury law firm of Sinyard, Timberlake & League. Named one of Alabama's top personal injury law firms by U.S. News & World Report, and has recovered more than $100 million for their clients. With founding attorney Tommy Sinyard, selected by the authors of Super Lawyers and Best Lawyers in America. Attorney Michael Timberlake, managing partner and top rated by fellow lawyers for legal ability and ethics. Attorney Will League, with experience trying and winning cases across the state of Alabama. Hosted by award-winning broadcaster and practicing family law attorney Sharon Goviet, and guests from across the Tennessee Valley. Your rights, your calls, live. This is WAAY 31 Lawline.
Welcome to WAAY 31 Lawline. Good evening, everyone. We've got the answers to your legal questions. Here is what's coming up tonight. In our caller segment, we'll take your questions about elder law, things like wills, trusts, estates, nursing homes, and probate. If you have a question, we would love to hear from you. Give us a call at 256-536-0077. In Legal Brief, what is taking so long? We'll also be responding to your email questions. But first, drinking and driving with your children in the car changes absolutely everything. Tommy Sinyard is back. How are you, Tommy?
Great. Good to see you again.
Very good to see you. Now, the law's different if you're drinking and driving with children in the car.
Absolutely. You know, you go from risking your own life and those other people on the road to risking a child's life, and it's endangerment of the child. The punishments go up, and they can be they go up as much as a felony, a year in jail. Generally, we're looking at a double sentence on the minimum. License suspended for 90 days, and this ignition interlock installed in the vehicle for 2 years. But it can go higher than that. It can be a felony to have alcohol and drugs in a car with a minor child. So people don't realize this. They say, oh, we just got some beer, or it's just marijuana. The favorite saying in Alabama is it's just marijuana. Well, it's not Colorado. The rules are very different here. So if you're going to have marijuana and your child in the car, you better be ready to do some time.
And this is very timely because the 4th of July is coming up next weekend. Typically a big spike in DUI arrests.
Absolutely. We have in Huntsville, and not to criticize the administration, but the #1 town in America for DUI arrests per capita. And there's additional money available for additional officers to be on the street. They can set up roadblocks. They can test people who have not violated the law in a routine road stop. So, there's enough carnage on the road without the drinking and driving and kids in the car. Let's pay attention during the 4th of July holiday.
And every single day for
And every
sake.
single day. It's just, life's too short. Let's be careful.
Absolutely. And we are joined now by another attorney.
Well, I guess one of my favorite people in the world is Connie Glass. She and I are peers, believe it or not. She just aged better than I did.
Aw, you both look great.
Connie is a statesman elder lawyer. An elder lawyer is a person that does wills, estates, probate. She does Medicare, trust, Medicaid questions, nursing home questions, and she's just excellent. She's been affiliated with the University of Alabama in the past. She runs what's called the Elder Law Firm. She is the gold standard, and my dear friend, we welcome her to Lawline.
Thank you. Well, and of course, we are talking about elder law tonight, and we would love to hear from you. We would love to take your questions. You've got a first-class expert here tonight, so we would love to take your calls at 256-536-0077. We don't have a call yet, but we certainly have an email question we can read out. My elderly mother has filed a lawsuit on behalf of my father, who passed away under suspicious circumstances in a nursing home. I hate to even ask this, but if my mother doesn't survive long enough to see the case go to court, what happens to her lawsuit? What happens to her lawsuit? Would I have to refile? And this question comes from Sharon.
Huh. That's a little bit of both of our worlds. I do nursing home abuse and neglect, and Connie does estate work. So once a person dies, Connie is one of the people that I go to set up their estate. A lawsuit can't be filed for a deceased person unless there's a personal representative appointed, and if there is a will, typically the person is designated in the will, and if there's not a will, family members can apply for the position with the probate judge, and Connie does the paperwork and determines who's a fit person to be the personal representative. And then that person, once the judge appoints them, can file the lawsuit. But Connie, should the personal representative die before the lawsuit ends, help us.
Well, if there's a successor named in the will of the personal representative, we get that person appointed. If there is no successor in the will, then unfortunately we'll have to go through the administrative process through the probate court to get a person named. And when you're naming someone who's not named in a will, you have to choose an Alabama resident. The court has no option but to choose an Alabama resident. And sometimes there are no family members here, so it may have to be the county administrator or a local lawyer who has to be appointed.
You know, people ask me all the time, because I'm a lawyer, although I'm not in your area, they just, why is it important to have a will, and if so, why, and what does it cost? Fill that blank for us.
Well, it is important to have a will, and as all lawyers know, it's very important because it gives you the opportunity to have a say about what happens at your death. If you don't write a will, the Alabama legislature's written one for you. And if you trust them to write one for you, then you and I need to talk, because we need to be in control of our own disposition of our assets. If we have minor children, we need to be able to name a guardian for those children in our will. And there are certain things that you can do in a will that you cannot do through an administrative process through the court administration when there is no will. So absolutely very important. How much does it cost? Depends on how complicated you want to get. You're looking from a few $100s to a few $1,000s depending on the complexity of your estate and what you want to do in the will.
Connie, I'm sorry, I have a question.
Sure.
What if you have emailed your desires to someone, possibly even an attorney, but you haven't gotten to that state where it's actually a formal will? Does that hold any water?
It does not. No. There's certain provisions that have to be in a will. It has to be signed by you. It has to be witnessed by two people. And if that is not done, that proper signing, the execution of the will, it's not a valid will.
Two people in the presence of each other and not related by blood or marriage. So, you know, emailing your will won't work.
Right.
Or just having a draft that you haven't signed yet.
The other thing, Connie, is, you know, I get asked a lot about what happens when my parents get elderly. How can I manage their property or their assets legally? What is the document you go to for that?
Our go-to document is really a durable power of attorney. There are a lot of people who want to do trusts, but I believe that most people's estates can be handled through a durable power of attorney. It's a document that you appoint another person to be an agent for you, to allow that person to make decisions, to make medical decisions, financial decisions, write checks, pay bills. It obviously needs to be somebody you trust, but if you have a trustworthy person in your life, that's the easiest and most efficient way to handle that process.
Okay, and we have a phone call on the line, and this one comes from Connie. And Connie, thank you for calling. What's your question for Connie?
If a home has been entailed until after the death of certain family members, what would a great-grandchild need to do when those family members have passed away to be able to take possession of that home?
If someone dies, I wasn't quite sure who the person was who died. I'm sorry, I didn't hear you very well, but when a person dies, the first step in the process to transfer title to real estate is either probate that person's will or to administer their estate if they don't have a will. Any interested person can start that process. So one of the family members needs to contact an attorney to get the process started through the probate court. There are certain steps that you have to take through the probate court to transfer title to real estate when somebody dies.
You know, wills, Connie's done will challenges, and that's kind of interesting to me. When you, if someone executes a will, let's say what you were talking about, on the hood of a car or an email, and they try to file that will for probate, the people that may have an interest in the estate can file to contest the will for either the lack of proper execution, which the will you outlined would be an email, for forgery, fraud, or undue influence. And a lot of times you see family members who are taking care of elderly folks who are right on the edge of being mentally competent and not competent, and they push the assets to their names. And those things can be challenged. I know you've had some significant estates, you've been through that process, but that's actually a war, isn't it?
It can be a war, absolutely, and it seems like the more dollars, the more lawyers you have in the room warring. But in Alabama, it's really hard to challenge a will. A will contest is pretty hard to win. And what I tell clients all the time when they come to see me about challenging wills, I don't like what mom did is not a grounds for a will contest. If mom had her capacity, understood what she was doing, was not being influenced by another person or under any kind of duress, nobody coerced her, committed fraud or forgery, then mom had every right to omit you. Even though you may not like it, she might have told you she didn't intend to, she still had every right to do it if she understood what she was doing. So I don't like it's not a good grounds.
All right, but I'm sure you hear it plenty of times.
Absolutely.
All right, we've got two great attorneys with us. We are going to take a break, but we want to hear from you. The Lawline phone number is 256-536-0077. We'll be right back.
This is WAAY 31 Lawline.
Welcome back to WAAY 31 Lawline. Let's go back to the phones. Up next, we have Mary. Mary, what is your question tonight?
My question concerns naming someone as your durable power of attorney. Do they have to be a resident of Alabama?
It's a great question. They do not. When people name someone to be a power of attorney for them, an agent and a power of attorney, it can be a person that lives anywhere as long as that person is an adult. The most important thing is, are they trustworthy? What I tell my clients to do is think about if you're in the hospital and you're unconscious, who do you want to have access to all your financial information? Who do you want to have the checkbook? And if somebody comes to mind, that's the person that you need to name in your power of attorney, because that's the person you trust. That is someone who's most like you to be able to make financial decisions most like you would do.
There's a regular power of attorney that does not survive incapacity. So let's suppose I gave you, Karen, my power of attorney, and that means you can cash my checks, you can take a mortgage against my property. You've got my legal bundle of sticks. A durable power of attorney is a power of attorney that stays with you after you become incapacitated by a stroke or a heart attack or unconsciousness or coma. And so the person that has that, the donee of the power, has a lot of legal power.
Absolutely.
And can essentially do anything that you can do. They can write a check as your attorney in fact.
Sell your house.
Sell your house. They can sell your car. So you want it to be somebody who will be responsible and accountable, because chasing that person after the money's gone is tough. There is a fiduciary duty of fidelity, but sometimes that's a hard chase.
But you have to go to court and enforce that, right?
Yep.
All right, thank you. Let us go to the second email question of the evening. My aunt recently purchased a house for her son. The house and mortgage are in her name. If she needs Medicaid for nursing home care in the next couple of years, what does she do? Does the house need to be sold, or can she just transfer it to her son's name? And this comes from Stacy.
This is the most important area that Connie works in. The law is insane, at least to me, about, I've worked my whole life, I have a home, it's worth $100,000, and now I'm going in a nursing home. What happens, Connie?
What happens? Most often the answer to that question is the home is going to have to be sold and used to pay for that person's care. Now, can they give that home away? Maybe. Very limited circumstances. If there's a spouse living in the home, the spouse would be able to live there, the home can be transferred to the spouse, and the spouse doesn't have to worry. If the lady's single and there is no spouse, then the only person to whom she can give that home without any penalty under the Medicaid rules is a disabled child, or a child who's been living in the home with her for at least 2 years and has provided care that kept her out of the nursing home. Some very limited circumstances. In all other cases, if she just gives that home away, then the Medicaid agency is going to impose a penalty, which means that they're not going to help pay for her care. And if she doesn't have $6,000 a month to write a check for the bill, then she's not going to have a way to pay the nursing home bill.
All right, Grandpa.
The planning, and they do what, a 5-year look back?
Look
the
back.
government does a 5-year look back. So if you say, I'm going to give my home to my kids because I might be going to nursing home in 6 months. Even though it's in their name, the government can look back and force the sale of that residence.
They actually just disqualify that person from Medicaid. That's the saddest part.
So,
they can't make them sell it, but they won't pay for the care for the person in the nursing home.
And you know, Connie, and I'm bragging on Connie, but among her titles, she served as the ombudsman for TARCOG, which is the Alabama Regional Council on Aging. So she's had to interact as a mediator between families and nursing homes. Tell us about the worries and concerns of nursing homes in general.
Well, no one wants to, I think if you interviewed most older people, they tell you they don't want to go to a nursing home, but there reaches a point in many people's lives where that's the only place they can get care. And the problem with that is nursing homes are $6,000 a month. Most of us don't have $6,000 a month to write a check to the nursing home, so we're having to look at alternate ways to pay for the nursing home, and that's where the Medicaid program comes in. On top of the financial worries, you have the worries of, is my loved one being cared for in the nursing home? And that's where Tommy's firm has to step in many times to look into abuses of care in the nursing home. Not all nursing homes are abusive to patients. Most are not. Most are great. Most provide excellent care, but there are a few bad apples that ruin the bushel for everybody. And those are the times when we have to step in and be advocates for our family members in the nursing home and the loved ones. And that's where, of course, firms like Tommy's get involved in advocating for patients who have been abused, neglected, and not cared for when they are at their most vulnerable.
All right, thank you so much. And we do have 2 callers on the line. We'll start with Karen. Karen, what is your question tonight?
Honestly, I don't know if anybody can answer it. What my question is a person that is on SSI, what is the rules about getting married? If they're totally disabled and they have a hard time taking care of themselves, can they get married without being cut off of SSI and Medicaid, or?
You're going to have a problem. SSI is supplemental security income. It's a needs-based benefit. So in order to qualify for SSI benefits, a person has to be either over 65 or under 65 and disabled and have limited income and resources. So for a single person, you have to have less than $2,000 in resources. And you also have to have less than, right at $700 a month in income. If you marry, and the person that you are marrying has $2,000 a month in retirement income or works and makes $2,000 a month, then you're going to lose your SSI benefits because your spouse's income and assets are deemed to you. It's called deeming. So all the people in the household, those assets and income are deemed to the person on SSI. So it's very possible that a single person on SSI and Medicaid could lose that benefit if they marry somebody that has more assets and more income.
Wow, that's very anti-family.
Yeah.
Yeah, some of these laws are tough.
They are.
All right, but we've got one more caller to get to before we go to break. Carol is on the line. Good evening, Carol.
Hello.
Hey, Carol.
I have a question I would like to ask. My elderly mother, who is 86 years old, passed away 3 months ago. I mean, 3 weeks ago. And I have a sister who is incarcerated for stealing money. She has a problem stealing money and lying, and she is incarcerated for about 10 years now. Before my mother passed away, about 2 months ago, she brought charges against my sister because my sister was stealing from her and charging on her credit cards. There was some accounts with both my sister's name and my name on it as beneficiaries. I think my mother personally died without a will because she didn't know what to do. I feel I will be made the executor of the estate, but what I want to know, what are the legal rights of somebody who is incarcerated? And my sister will owe back to my mother's estate. Thank you.
Well, interesting.
It's a great question. I don't know that I know the answer to that one.
Well, I know this, that of course a person can't kill you and benefit from the will, but this is one of the premier reasons for making a will. I know of no law that eliminates your incarcerated sister from taking, either as a beneficiary of a life insurance policy or an annuity, or under the will just because she has been charged with a crime. That's sort of a unique question, but my gut reaction, and this is more Connie's area, is just because she's had a faux pas or a theft in the past does not eliminate her from taking under the will. Now, she may have to pay back her previous obligations where she took money and there's been a offset, and there might be an offset. Right. But I don't think you can say, oh, she's a bad girl, she doesn't get anything under the will, especially when your mother didn't exclude her by making a will. So that's yet another reason to look at making a will.
And the beneficiary designation is even different. The bank is going to pay as a beneficiary to whomever's name's on there.
Yeah,
it doesn't matter where they are.
It's contractual. It doesn't even go through the estate.
All right, thanks. Very good answers and very good calls. We will be right back after we take a short break. Stay with us. And here are the upcoming dockets. Next weekend, July 6th, DUI. July 13th, you'll want to hear about disability benefits, and tune in on July 20th to hear about car and truck accidents. We are talking about grandpa and the law, we are talking about elder law, and we have George on the line. George, what is your question?
If the executor of a will and one of the siblings take all the personal items of the will and do not share equally with the third sibling, is there a legal action, even though you can't prove that they took the stuff?
You're talking about personal property, coins, knives, guns,
exactly. Furniture.
And what?
Furniture.
Things inside the home.
Furniture, things in the house. That's the hardest thing to deal with.
Movables.
There's no title. They're not titled assets. There's no evidence that those assets exist other than that everybody says they were there. You know, if the will says everything's to be divided equally among 3 children, then each of the children is supposed to get an equal share of the proceeds of the personal property, or a third of the personal property. What happens is so often you can't divide that personal property fairly and equally. So then what happens? Everybody just kind of goes in and takes what they want. Is that an equal distribution? Absolutely not. What the court will end up doing, if you go into the court before the judge, is the court will simply order it all be sold and the money divided, because it's fairly easy to divide dollars. But if there's not evidence that those things existed and the person who took them is denying it, and you don't have any proof of that, it's almost impossible to get any sort of restitution for that personal property.
Or the cost of battling in court exceeds its value a lot of the
because
time.
it's sometimes sentimental value.
Yeah, it's sentimental. It doesn't have a great market value for the chair or the couch,
Grandma's quilt.
Yeah.
Oh. Yeah, it's so tough when you're dealing with the loss anyway, and then to throw these other factors in.
And it happens so much. The first relative to the house runs in.
Snatches up everything.
Yeah, I know we got to go, and I know this is totally inappropriate, but my second son graduated from college and leaves tonight to go to South Carolina for a job, and I just want to tell him I'm so proud of him, and I can't believe it's done. Riley Senior, I wish you love.
Riley, we all wish you love and luck. All right, we're out of time tonight, but tune in next week for DUI. And again, if you have any questions about elder law, call Connie Glass at 536-9494. Have a great week.
Thank you. Good night, y'all.